Good morning or afternoon, depending upon where you're joining us from today. My name is Dominic DeMatties, and I would like to welcome you to today's webinar. I'm a partner in the Employee Benefits and Executive Compensation practice in our Washington, D.C. office. I am joined today by my colleague, Brian Gage, from our Cleveland office. Brian and I will spend some time exploring the recent opinion letter that Thompson Hine recently received from the Department of Labor that confirms Citibank's ability to pay some or all of a diverse investment manager's fee in connection with its plans as a settlor function. To proactively address a question we frequently receive, today's webinar is being recorded and will be sent to all registrants within approximately 2 business days. During today's presentation, please feel free to use the question panel at the upper right-hand corner of your screen. We will answer questions either throughout or at the end of the webinar as time permits. To that point, although we have set aside an hour for this webinar, Brian and I do not plan to use that entire time based on our prepared materials. Instead, we expect to take probably the first 30 minutes or so of our time presenting, and thereafter, we will use the remaining time to answer any questions that have come in that we're able to answer. So as always, feel free to ask questions. We do expect to have some time to answer them. It's important to note that even though we requested this guidance that we're going to discuss today on behalf of Citibank, this webinar and the presentation materials are our personal points of view provided for your general information. This is not legal advice, and nothing discussed today or included in the presentation materials should or can be attributed to Citibank. Finally, if there are any members of the press, our comments today are off the record and not for attribution. If you would like a comment or have specific questions that we may be able to answer, please contact me after the webinar. And now we will begin today's program. So stepping back, looking at from a big picture perspective, the Department of Labor issued an advisory opinion. We'll talk a little bit about what an advisory opinion is. In which it approved a Citibank program under which Citibank will commit to pay some or all the fees of a diverse investment manager in a settlor capacity without its conduct being considered fiduciary under ERISA. And this is really the key, and this is the critical element of the guidance, the idea that what's occurring here is settlor in nature, which we will discuss further. As an aside, the letter states the city expects a manager will qualify as a diverse manager if it has total minority or female ownership of at least a specific percentage, such as 50%, based on an investment management firm database over which Citibank has no control, influence, or role. This program that was approved is part of Citibank's larger action for racial equity, which is described more fully in the opinion letter. And as I noted, the approval that we're talking about is the form of an opinion letter, an advisory opinion issued at Thompson Hine on Citibank's behalf. One of the most important aspects, and I know I'm going out of order on bullets, which, sorry, I like to do that. One of the most important aspects to keep in mind about this program is that it is completely optional. There's no requirements, there are no mandates. There's not even a negative implication for a plan sponsor that does not wish to establish this type of program. Another aspect of this that's important, at least to recognize, is that this is the very first guidance of any type from any of the agencies that regulate ERISA plans regarding how a plan sponsor may permissibly pursue DEI or similar initiatives in connections with its service providers for its ERISA plans. Unstated in the DOL guidance and in these bullets that are listed on this page, the actual design of this settlor program can be quite flexible. And the logic in the opinion can, with an appropriate consideration of applicable legal considerations, be applied to other plan sponsor initiatives, making the guidance even more important for plan sponsors that do not wish to set up a program such as that described in the letter. In other words, just because you may not want to set up this particular type of program, the guidance is still important to the extent that there may be a desire to set up other programs. Based on our experience of more than a 2-year period, thinking about and then ultimately requesting this opinion letter, we are very familiar with the aspects of the program and the processes described in the advisory opinion that were critical to Department of Labor approval, and those aspects that were less, or in some cases, maybe even not critical. And with that, I'll turn it over to Brian for a brief discussion of advisory opinions.
Thank you, Dominic. An advisory opinion, one is sought when a company or plan fiduciary wants to have the Department of Labor opine on the application of the law to a specific factual pattern. The Department of Labor is not required to issue an opinion letter if one is requested. It is optional on their part. In the early days of ERISA, they were more frequent. It was a general practice that the Department of Labor did issue maybe 5 or 6 a year, but in recent years, they don't issue very many. And so this is actually the first one, and since I think it was 2020 that they've issued an advisory opinion letter. And so because an advisory opinion letter is the application of law to specific factual pattern, it really can only be relied on by the party to whom it is issued. I mean, that's basically it. It's Citi's letter. Now, having said that, the opinion letters are a roadmap of how the Department of Labor views issues. And as practitioners know, we often look to opinion letters for a sense of guidance regarding what the law is and how it would apply into similar situation. And so even though it's only Citi's, we pretty well expect that others will follow this without necessarily getting their own opinion letter, or somebody might try to, one route is to consider whether or not, if there's significant difference between what they want to do, is to seek their own opinion letter. Now, one of the things about this opinion letter is that it takes a long time to receive it. This isn't a 2-week process. It's not even a 6-month process. It actually took 20 months from the time that the submission was filed to when the Department of Labor issued the opinion letter. And there was numerous back and forth with the Department of Labor regarding the issues. And so it is well thought out. This isn't, something that the Department of Labor spent very little time on or just issued. They gave considerable thought. And they actually, from my perspective, issued an incredibly good opinion letter. I mean, they drafted, they don't share the legal analysis, prior to it. So it's not as if we knew exactly what they would say. But in this case, they actually said a lot of good things just in general, and really comports with what we think the law really does state and permit. And we've heard from other practitioners really saying the same thing, is they looked at this and said, yes, this really is a good opinion letter. It comports with the law and says what the law is. And so we believe that it is rock solid on the guidance. I mean, within this fact pattern, but just in general, we think it is very well written and very good. What the last part of this one slide is, although it's his opinion letter, one of the things that we know that there's a lot of litigation on ESG at this time, and we think this is different than a lot of the ESG guidance. And in one aspect it is because the pure ESG really focuses on the investments, as far as what are you going to consider as an investment. Well, this program, the unique part of it, and really the creative idea that Dominic actually came up with was that you change what could be viewed as a ESG factor or diversity into a pecuniary factor. I mean, that's the essence of this program, is that there's a fee commitment saying you're allowed to use these subsidization of the fees, and that's purely financial and economic, rather than viewing it the issue or looking at it from like the ESG perspective.
Brian, just a couple of points on that last slide. As you noted at the end, there are, yes, there are potential issues and similarities and differences with respect to the ESG litigation. I'll say personally, I don't see showstoppers from that perspective. But, depending on how one might want to, say, use this particular piece of guidance as a roadmap, so not speaking to the city program, but speaking to what, say, another plan sponsor may wish to do, there would be important considerations. It's just because, we're saying that we think this is distinguishable and we don't think they're showstoppers in particular with respect to the program described, doesn't mean that, if another plan sponsor were to use this to do or to rely on it for something similar, that there wouldn't be issues to at least think through. That's number one. Number two, this actually goes back, it's kind of an unrelated point, but it struck me as you were talking, which is, and I think this is important to understand from the perspective of how advisory opinions work. You talked about that there were, there used to be more, there were a number of opinion letters. When you request an opinion letter from the Department of Labor, it is similar, almost analogous in some ways to, say, a private letter ruling from the IRS, essentially asking the agency to opine as to the law with respect to a certain set of facts. But there's a huge difference. When you go to the IRS and you ask for a letter ruling, if you find that they're not going to rule in your favor, you can kind of say, just kidding. You can walk away. With the Department of Labor, when you request an opinion letter, and there are some, if you go back and search prior opinion letters where you could tell this was the case, if you request an opinion letter and you find that the Department of Labor is going to be adverse, that they disagree with you, they can go ahead and publish that letter, and they have. And so the point being that, they have a very easy mechanism with these types of requests to easily say to the public, no, we disagree if they do. And obviously in this case, that's not what they chose to do.
Great, thank you, Dominic. So on our next slide, the whole structure of this idea that Dominic came up with was, we have two parts, and it's always the two-hat theory is what they call it, is that, when you can act in a settlor capacity, and when you act in a settlor capacity, that's when you're responsible, plan sponsors responsible for establishing, designing, funding, amending, and terminating a plan. In that capacity, the plan sponsor is not bound by ERISA's fiduciary duties, and the plan sponsor can, and in practice does, consider its own interests, including the legitimate business objectives as well as the financial consequences of the decision. The easiest example of this is that clearly if a plan sponsor wants to terminate a plan, well, that is their decision. They can do that. They don't have to worry that terminating a plan is going to take away a benefit from participants and beneficiaries. It's a settlor function. They have the ability to do that. Fiduciary functions are really the implementation of the plan sponsor's decision. Once the plan is created, a written plan document, the fiduciary is to implement that. And there are administrative implementation items, discretionary administrative items, and there's also investment implementation items. And in those areas, when implementing the plan design, when implementing it, plan fiduciaries are bound by ERISA's fiduciary duties to act prudently and solely in the interest of plan participants and beneficiaries, and for the exclusive purpose of providing benefits to them and to ensure that the plan pays only reasonable plan expenses. So the focus for the fiduciary is on participants and beneficiaries. The focus is not on the settlor. And in the ESG guidance, to segue here for a second, is that one example that they always gave is in the multi-employer plan area where you have a multi-employer plan fund and they business is down and they said, oh, why don't we use our money from our plan to create jobs for our bricklayers or plumbers or pipe fitters, and you can't do that. I mean, because you're really considering not their plan participants' interests. You're actually trying to influence or looking at considerations outside of that. So again, the whole thing is the interest of plan participants and beneficiaries, and including in that fiduciary capacity is decisions regarding hiring and overseeing service providers to a plan are fiduciary. And so regardless of you, if you're picking investment managers, if you're picking record keepers, anybody that you're selecting to implement the plan is a fiduciary decision. And so on investment responsibilities, any exercise of discretion over plan assets is fiduciary conduct. Decisions regarding a plan investment or investment course of action are fiduciary. Hiring service providers is fiduciary conduct that must also satisfy a prohibited transaction exemption, which is 408B2 is the exemption number. And then this is the key thing, all prior attempts to incorporate DEI or ESG type considerations into ERISA plans have been through guidance regarding the fiduciary aspects of taking those considerations into account. And that has led to basically sub-regulatory guidance for a long time regarding when you can consider ESG or not, and also more recently in the form of regulations. But those are always focused on what a fiduciary could do. And as we said, a fiduciary has to act in the best interest of participants and beneficiaries. But what this program and what was put forward is, well, what can a settlor do?
Right, that's exactly right, Brian. So ultimately, what we have here is a new alternative. A new alternative if the settlor, and what can the settlor do to incorporate, and what the guidance essentially does is outline what a settlor can do to incorporate DEI, ESG type considerations or other considerations into its ERISA plans without the conduct being fiduciary, which is critically important for the reasons Brian mentioned. These 30 years of guidance, ultimately resulted in 2 final regulations in the past, 3 years. We had a 2020 final regulation under the prior administration and a revised regulation under the current administration in 2022, which interestingly enough, notwithstanding the large amount of press and reporting around those 2 various regulations, the Northern District of Texas recently concluded that those 2 regulations are not materially different in the most substantive respects, and that there was little daylight between them. But that, kind of leads to part of the problem, which is that, there's a lot of confusion, angst, concern regarding the fiduciary side of this, which, by the way, is still available. Obviously, fiduciaries can still do what they're able to do in accordance with the rules, and we'll talk about that a little bit later. This doesn't replace or change any of those fiduciary rules. This letter instead stands alongside of that as essentially this new alternative. And the thought process underlying this letter, and I think, Brian, I heard you earlier refer to pecuniary, which for those of you who are familiar with the dueling rulemaking will recognize that that was the word in the 2020 regulation from the prior administration. And our view is that this letter and the guidance in this letter holds up even under that standard. So what are the most significant issues addressed by the opinion? And we're going to get into the details of how the program works in just a bit. First, Citibank's conduct in establishing and maintaining a program, a diverse investment manager program, and committing under that program to pay some or all investment manager fees is not subject to ERISA's fiduciary duties. And the applicable plan fiduciaries do not violate their fiduciary duties and do not engage in a non-exempt derivative transaction by taking into account, being aware of, and taking into account the investment manager fees that will be paid. But they need to do that within their ordinary prudent fiduciary process for evaluating and retaining investment managers for their ERISA plans that hold plan assets. There's also a third issue addressed by the opinion, and kind of a technical issue related to disclosure of the program, approving essentially a disclosure regime that would not affect the availability of ERISA 404C, which generally requires that there be no improper influence with respect to a plan's investment options as for an individual account plan, 401k plan, and that it also requires that participants have independent control over their investment decisions. So this influence, this idea that, that the existence of the program itself doesn't create an improper influence or affect the independence. So now turning to program design. So how does this work? And this is all outlined in the letter with more detail, so we'll just briefly go through it just to get it out there. So Citibank predetermines an amount that it will allocate to each of its plans that are eligible for a commitment for a fee subsidy on a plan-by-plan basis. Any agreement to pay a diverse investment manager's fees as part of the program would last for a minimum of 3 years, so that the plan fiduciary can rely on it for a stable period of time, make decisions regarding the duration. And also that essentially corresponds with what might typically be an ordinary review pattern with respect to investment managers in the regular monitoring and oversight. And there's no elements of this program that are intended to produce a monetary or tangible financial benefit to Citibank. There is the reality that for those people who like the fact that Citibank has this program, it may create a halo, but there's no monetary or tangible financial benefits. There are conditions designed to limit Citibank's financial obligations under the program. So it's not an unlimited commitment, and to further Citibank's purposes in adopting the program, which of course is okay. Citibank is permitted to further its purposes because it's a settlor program. These include an anticipated cap on the total amount that would be available to pay investment management fees under the program, a cap on the amount that would be payable to any individual manager, a first-in-time selection mechanism to allocate amounts available under the program as between different investment managers. This also helps the plan fiduciaries understand how the fee commitment would be paid, and maybe limits on certain types of fees, such as incentive fees. Brian will talk to us about some of the limitations.
With respect to the program limitations, the key portion of this is to basically make sure that what Citi is doing is settlor, is that they're staying within the settlor realm, and that the fiduciaries are allowed to do what they do. And so first limitation is that there's going to be no attempt to influence any plan fiduciary in its decision-making process regarding use of the program or mandate that a plan fiduciary engage in any particular search or selection process. What that means is that the fiduciaries are going to go through their usual process, and it just happens at the point in time when they consider the fees and comparison at that point in time is looking at the fees of one provider versus another. They actually can have this commitment and take it into account and say, wow, we really like this manager. Their investment performance has been incredibly good. But the other manager has more assets under management, and that other manager, because of that, their fees are lower, and maybe don't feel as comfortable saying, oh, can we justify going with somebody we think is a better fit and will give us, better return, when we have another provider has lower fees. But this removes that impediment and says, all right, diverse manager, we like what you're doing. You're totally qualified. You're great. We love what you have. And we're going to use part of our commitment to reduce your fees to, I don't know, wherever you want, equal to the other manager who has more assets under management and is larger and has been in the business longer. And so there you are. We're going to use that. And so now we're on an even playing field as far as fees. Fees are equal between the two. And now the fiduciary can decide and say, yes, we really do like the diverse asset manager. We think they're going to bring a lot to our portfolio and a mix of managers. And we think having them in there is going to provide better results for our participants and beneficiaries. And that is one thing, as a segue, just in my mind, is that this is very good for participants and beneficiaries because it's always good when the plan sponsor pays fees that would otherwise be borne by by the participants. And in this case, you have the added benefit of actually selecting a provider that you think will do even better on the return side. The second program limitation is no consideration of a plan fiduciary's use of the program or lack thereof in making any decision regarding that plan fiduciary, including without limitation in the exercise of Citibank's residual fiduciary responsibility to appoint and monitor the plan fiduciary. So, Citi's making this available. The fiduciary doesn't have to use it. It may just, find that, it's what the current list of managers is great. They don't have to go out and actually say, oh, let's replace our current managers or anything. If they're, it just says, and because of that, there's a limitation. Citibank's is not as a settlor going to take any action with respect to that fiduciary, either in monitoring that fiduciary or otherwise. It's, the fiduciaries, they're going to do their business as usual. And my experience of fiduciaries take their responsibilities seriously, and they'll choose what's best for the participants and beneficiaries. And then third is no plan sponsor rights regarding investment manager selections or allocations. The plan sponsor merely pays or reimburses fees that would otherwise be paid by the plan. Again, all that Citi is doing is saying, here's this commitment, we will pay the fees of diverse managers. Fiduciary, consider that in the process. And the fiduciary will do that.
Just one point of clarification, just to follow up on that. What Brian, some of the commentary regarding, say, for example, like a fee levelization that Brian just talked about. Just to be clear, that's not a requirement. That's not a limitation in the program that it be designed to be a fee levelization, if you will. Brian's providing that as an example of how one might implement the particular limitation as described in the letter.
Yes, correct. And so then the next limitations, the plan fiduciaries will not be required to explain program related decisions with respect to investment manager selection. So again, fiduciaries operate as usual, and they don't have to report back and explain, well, why haven't you used the program, or why did you use it in this way? All of those, fiduciaries, again, they're the fiduciaries. They're going to do their role. Citibank as the settlor is not going to interfere with them. There will be no numerical goals or similar requirements established regarding engagement of diverse managers that a plan fiduciary must meet to receive reimbursements under the program. Again, there's no quotas, no nothing. It's available. The fiduciaries will take it into account. And again, this is dividing these. The Citi isn't going to be going. These limitations are designed so that one is not asserting that in actuality. And again, I said Citi, but anybody who adopts this type of program or anything else is that they're not really influencing the decision-making process. Because if you're participating in the decision-making process, there's a possibility somebody would say, yeah, you are a fiduciary. You might not describe yourself as, but we do know somebody could be a de facto. I mean, by their actions can be considered to be a fiduciary, even if they're not named as one. And then no investment manager who is a party in interest or in which Citibank has an interest that might affect the applicable plan fiduciary's best judgment or otherwise create a conflict of interest under the fiduciary and prohibited transaction provisions of ERISA is eligible for fee payment by Citibank. So, this isn't Citibank or somebody affiliated with Citibank is going to be the one where the fee reduction is used. So again, it's not as if the settler's not choosing at all who's going to get the benefit of this, other than it's going to be a diverse manager. The fiduciaries decide who's going to get the benefit of this program, if anyone, in a fiduciary capacity.
So with that, as we've alluded to, this program, this letter, this piece of guidance, if you will, stands alongside existing rules. It doesn't replace them. It doesn't change them. It doesn't, there's not one way that's better than another. There are two available avenues, and this just really opens up a new avenue. Specifically, and the Department of Labor made a point of this in the letter, that, you know, a plan fiduciary may, in accordance with the 2022 final regulation, a plan fiduciary may, and actually must, you know, any factors that it reasonably believes are relevant to the risk and return analysis it needs to consider, and that may, depending on the individual facts and circumstances, include risk and return factors that may include economic effects of climate change and other environmental, social, and governance factors on that particular investment or investment course of action. And so obviously, you know, this type of program would feel like it may be described in like those types of factors, but in fact, because it's settlor in nature, it's just a different avenue, a different way. The relevant to the existing fiduciary rule, existing rule on fiduciary conduct that's relevant here, the 2022 final regulation. The Department of Labor did conclude that the program itself, any individual commitment to pay fees of the program, are financial factors relevant to the risk and return analysis that a prudent fiduciary could consider, among others, in selecting an investment manager. The opinion does not change the department's clear and consistent view that plan fiduciaries must fully understand a service provider arrangement, including the quality and cost of services and any associated risks, and avoid conflicts of interest. And there's an explicit sentence in the letter stating what, you know, we all know to be the rule, that a plan fiduciary should not consider any one factor, such as the lowest bid for services, to the exclusion of any other relevant factor, such as the quality of services. It's an interesting statement, even though it's well settled, but it's interesting to see it in black and white so clearly, because I think we know there's a lot of litigation related to 401k plans in particular, where the plaintiff's claim essentially is you should have focused on the lowest bid. So this is a pretty good defensive line to that. And as noted earlier, you know, disclosure of this program and payment of fees under the program does not affect the availability of ERISA Section 404C, which was important to the extent that this program or something similar might be used with respect to an individual account plan. Now, in addition to, you know, the questions related to the challenge that Brian mentioned before, you know, we've also had to think through, as part of our process, various tax issues. So Brian's going to take a minute here to walk us through our thinking.
Yeah, there's a line of private letter rulings and guidance that the IRS issued that, in general, we know that a plan sponsor can pay administrative fees of a plan. And it's really clear, and most of the language says in documents that, you know, basically the plan sponsor reserves the right to pay the fees. And if the plan sponsor does, that is basically deductible under Section 162. It's not considered to be a contribution to the plan. And then there's these private letter rulings that said, you know, there are certain things, and they focused on brokers' fees that are really tied to the investment themselves, that really are more akin to the investment return, I would say, or just kind of part of the investment, that the IRS said, you know, plan sponsor, if you actually paid those fees, we really think that you're making a contribution to the plan, and that contribution is going to be subject to the restrictions of Code Section 415 as far as annual additions. This is a 401k, you know, the annual additions to a plan. And so, you know, the concern is, in this situation, what about these investment management fees? Where do they fall? Is this just like payment of trustee fees, administrative fees, that if you pay these fees, that it's basically going to be deductible under Code Section 162. It won't be considered to be an annual addition under Code Section 415. Or is it more akin to these like brokerage fees or something inherently tied to the investment itself, so that you're really kicking in an additional amount for the benefit of the participants, i.e. kind of we're enhancing the investment earnings. And I think the guidance is fairly clear. We think it's strong arguments that this falls on the side that it's not going to be subject to 415. It's not going to be considered a contribution to the benefit plan on behalf of participants. It's just going to be deductible under Code Section 162. But like all things, one needs to, in this area, one needs to be careful. It's, again, those are PLRs, some of the guidance. And so, you'll always want with all of these, depending on your facts and circumstances, to get your counsel, weigh in. We'll be glad to look at it and focus on it. But in general, we feel pretty good about in general that these programs or what's being done can be structured, or at least in a way that we feel pretty confident that the taxation is really how you would want it to be, i.e. that you're not going to all of a sudden be having to calculate how much participants can add this to the annual additions to the plan for 15 testing.
So with that, we're getting pretty close to being able to wrap up. And, I think we've tried throughout this presentation to weave in questions that we had received to date. But while we're waiting to see if any new questions come in, Brian, you and I were talking earlier about, kind of just holistically in terms of the group, just to make sure people are aware. I mean, obtaining, this type of letter from the Department of Labor is just one aspect of our firm's abilities related to Title I of ERISA and plan asset issues. In addition to Brian and I mean, we're the ones who are speaking today. There are many members of our group who have significant experience with these issues. Brian, do you want to say a few words about some of the other aspects of our Title I practice?
Yeah, sure. I'll be glad to. So we do a variety of work on the investment side. I call it pension investment work, and I would say maybe 30 to 35% of the time I spend is on pension investment. That could be anything. We recently doing a deep dive into securities lending arrangements, as far as whether those are, how they're being operated for a plan, reviewing a collective investment trust, really everything, top-down, thorough review of a collective investment trust for a national bank. We also, again, those are more, that one is on the banking side, the side of it, but definitely look at collective investment trust for plan sponsors who invest in those entities. Do a lot of private equity work, or have done a lot of private equity work, where we have plans that invest in private equities, to review those documentation from an ERISA perspective to make sure it's structured in a way that conforms with the fiduciary rules and the prohibited transaction rules, and what's a plan asset or not. Once in a while, I was real fortunate to get a project on foreign exchange transactions, and for a bank about how do they structure or negotiate ERISA provisions and foreign exchange transactions, for, again, more on a defined benefit side as far as having those. We also have done a lot of OCIO, the outsourced chief investment officer contracts, and follow up on that, and have really, I think, served our clients well, just to how those are structured, and making sure everybody understands their responsibility. And so this is really just one aspect of what we do. I mean, we do a huge, again, 30 to 35%, and that's been growing. And we do have clients that we actually don't do the executive comp, welfare plan, or traditional qualified plan, but we do the investment work because it's a good niche. And so, but we also do all the other stuff too. And so that's it. Oh, I see we have a question, Dominic. And the question is, what do people do or have done without regard to this type of program? Because this is an alternative. Can you speak a little bit more about how people addressed these questions without this type of program, and what the balances and thoughts are on that?
Yeah,
I can speak to that too if you want, Dominic, but I'll let you go first.
Well, I can start a little bit. Yeah, we can both pipe in, of course, as we usually do. I mean, I think, as a starting point, as we've noted, this is one alternative, and it's an alternative to something that's been in existence for a while, which is that, through a fiduciary process, there are permissible ways in order to, make a decision as to whether or not these types of considerations are relevant to risk and return. So you have that. It's not entirely, Brian, maybe it might be clear to you, and for whatever reason, I actually can't see the question in front of me. I don't know why, but it's not entirely clear to me what other aspects of that question may be going to. So if you want to jump in on that or spur my brain, that would be great.
Yeah, I think the question is, are there programs currently out there that people do with respect to diverse asset managers or diversity in asset managers? And I think part of this, let me give you a big picture comment on that, is that there are studies that say that investment managers, diverse investment managers, are a pretty low percentage of the population of investment managers or have investment assets under management. And so there is a feeling, and I know Congress at one time was soliciting comments and for analyzing or looking into the issue is, why is the participation rate so low for diverse asset managers? And so I think others have tried other alternatives or have looked at this and have done certain programs. And so that was the focus. And maybe go ahead.
Well, let me add to that too. I mean, to your point, I mean, the studies, they indicate that there's an underrepresentation of, diverse investment managers essentially at having a seat at the table, but that underrepresentation is not related to, say, investment return or other performance, which is, I think that's the key part, and that, that can, lead to a school of thought, well, or it may show itself out sometimes anecdotally, that a fee leveling, as you described, or some type of fee program can be helpful to address that, because the real issue can be assets under management, leading to an inability to compete on fees.
Yeah, and the other part of, I think, is that in those studies, and there is, I forgot what they call it, is it the diversity initiative? I think it's the group, is that there is a line of thought that diversity, and I think it's shown, I mean, there are companies who follow this path, is that diversity in of itself of investment managers may or can enhance returns, because people have different perspectives on it and on how to invest or to go about it. And so if you have a simple kind of cookie cutter, we'll go with the largest provider, you may actually be giving up something. And so there is guidance out there, and there are plan fiduciaries and sponsors, plan fiduciaries who actually will at times under the regular, because as Dominic said on a few slides ago, is that fees are only one aspect of the equation. You can look at quality of services, you can look at this other things, and as a fiduciary, if you look at all the factors and you say, well, even though this manager isn't providing perhaps the lowest fees, we really think this provider is a good fit and is going to add something on the other side of it, and will go forward and basically select a diverse manager because they think they bring something to the table that will help the overall economic, financial, risk and return, pecuniary, whatever language one wants to use. And if you go down that process, you really are falling more into the quote ESG analysis. And we could go into, if people think it's, or Dominic, if you think I can go kind of a segue into a little bit of the history of ESG and a little bit of that. But really what's happened over the years is that at one point in time, one administration would say, a lot of these social issues really are economic, and they really, people need to focus originally on proxies, that there are a lot of proposals come before companies and shareholders, and part of the fiduciary responsibility is not only investment, but it's all the rights associated with that. And as fiduciaries, you have the responsibility or have the ability to vote, and we think you really should pay attention to these situations and vote, and that these social issues, ESG issues, environmental, social, and governance, are things you should be analyzing and really voting on it. Well, then the next administration comes along and says, oh, no, you're not supposed to be activists. You're supposed to be aiming to get the best, return financial, and you really need to be very careful before you decide to use your power as the fiduciary of a plan to be advancing social causes. And that kind of back and forth, and then in the immediately preceding administration, they came out with a regulation that really put a lot of bells and whistles on the guidance, saying if you're going to consider ESG, you're going to have to document this, you have to do a variety of things, you're not allowed to have it in your QDI, qualified default investment alternative. And so really what happens on that was, there was kind of a thumb on the scale. The standard never changed. I mean, the standard is, as we said, is you always look at risk and return analysis, the financial benefit of the retirement participants, plan participants, and you're never allowed to subordinate those interests to other objectives. And right. So, but they kind of going back and forth as far as the thumb on the scale. Then the proposed regulation came along, this current administration, and they kind of flipped it and said, oh no, these ESG things really are pecuniary, financial. We don't like the word pecuniary because nobody understands what that really means. It seems kind of like a Latin term. Let's call it risk and anything that goes to the risk and return. And then the final regulation from a person who advises plan fiduciaries is the ideal one, or good is that it allows the fiduciary to decide, is right. That fiduciary can decide. And the recent case in the Texas, it recognized that. It said, the basic standard hasn't changed, and the Department of Labor gave good reasons why they were changing it. And the real, and this is my caveat or the process, the real truth in one sense is that it's clear in some cases what you can't do, like that one I used with the union plan example, saying, oh, hey, or somebody believes in a cause and say, hey, we're just not going to invest that way. And if you don't do any process or analysis on the financial, you're breaching your fiduciary duty. But if you actually do a deep dive and look at the process and say, hey, I think this factor is not really being considered in the market. I think this social issue or governance issue or environmental issue really is going to have a financial impact and down the road, or even in the short term. And we think the market is not adequately considering that. So we think this is a great investment. And I think that's, in where somebody views that, there's going to be a spectrum of advisors. Some will, some social issues or environmental or governance issues gain traction over time, and others kind of lessen. And it's up to the fiduciary to say, hey, I think this is important. And some may say this is, and some may think not. And then, in their best judgment, they give their advice. So it's really going to be, but it's in a good place right now, but people sue. And so again, the Fifth Circuit upheld it, the district court in the Fifth Circuit. But there are other suits that are, another suit up in Wisconsin that, some participants challenging it. And so there's always this, discomfort because of the extensive litigation with 401k plans now, that, if you have anything that kind of says, we might have something's ESG, or we took this factor into account because we think it has a financial effect, maybe somebody's going to try to second guess you, and where the alternative doesn't have that realm, but people do go that, but to tell you the truth, with all of it becoming a pretty hot political issue, the whole ESG issue, is that I think people have tended to shy away from doing a lot of, maybe some of what's previously being considered. I don't know, Dominic, if you have a flavor on that, and please speak up.
Yeah, no, I mean, I agree with that. I mean, and the bottom line, I think here is, under this alternative with, this opinion letter, this advisory opinion from the Department of Labor, this provides a pathway to avoid that issue if that's the desire, right? To not have this in the fiduciary realm. And all that stuff that Brian just went through, the volleys, the back and forth, the being subject to the whims of an administration and whatnot, can kind of, in some ways, can be mitigated. We do have some other questions, and so let me just turn to that just real quickly before we wrap up. One of the questions here is about the 3-year period. There's this 3-year period that's specified in the guidance. Essentially that it's the commitment, that the commitment would be for 3 years. So I think there's a lot of different ways to think about that. I guess my reaction would be, and there's some concern here, well, gee, is 3 years too short, essentially? What I'd say is that from remembering again now, so now we go back from this being a roadmap to this being issued to a particular company, right? And that's their program. That's the program that they are designing, and that has a 3-year commitment, and that works, for them, or it would work for them with their ordinary processes that they have in place, the fiduciary processes with which this will correspond. So, I mean, this is one of those aspects that, some thought could be given depending on the individual facts circumstances. Is, well, if the 3-year period is a concern, well, then, if there's an analysis to be done, well, how could we vary that 3-year period? Could we have a longer period? Could we have a shorter period? And, you'd want to consider, the various, any of the various concerns from either side with respect to that. So, but that's what I'd say about that is just remember that that's kind of the program design. And then we had other questions related to kind of talking a little bit more about the ESG scenarios, which I think, Brian, you've gone through quite thoroughly. So I think with that, do you see any other questions, Brian, that we haven't addressed?
No, I think we're good on that. And but again, just the notion, the 3 years, Dominic said, you want to have at least some period of time where it's the commitment's there, because otherwise, how can a fiduciary really factor in the value of the commitment if it was something that could be pulled away in one day, et cetera? And so, I think the thought is that, you're right, long-term, usually managers, you wouldn't replace somebody earlier than 3 years. A lot of companies say 5 years, maybe some more, but it was just, I think it was just the starting point. And again, I think you're right, Dominic, that you can balance it. Somebody might want to go more, or at least it's a minimum. It works.
Right. I mean, and it seems to me, you think through it, right? Again, everything has to be analyzed on its individual facts, circumstances, but it is hard to imagine that if the only variation from the program were a longer, I'll call it stability period, this commitment period, if that were the only variation, it is hard to imagine that somehow would be critical to the analysis that's set forth in the letter. Okay, well, with that, I think we'll wrap up. Thank you to everyone for attending our presentation. As I mentioned earlier, we will send today's recorded webinar and slides to all registrants in approximately 2 business days. If questions arise as you consider the issues that we discussed today, please reach out to your Thompson Hine attorney. If you aren't currently a client, please contact me or Brian, and we will discuss available options to address your needs. Thank you so much, and enjoy the rest of your day.